Very much, Council President. There have been a lot of issues that have faced the city, and fortunately the media has reported on it, and I appreciate all the council members who have been very actively engaged. I would like to talk about something, however, that I came across last week. While I was away, a woman came and left me a booklet, and it was about her son. His name is Eric Mann. And I agreed to meet her, but she wanted me to read the booklet, and I did read the booklet, and it reminded me of something that I had experienced many years ago as an attorney, and that is when I came across Pennsylvania's Post-Conviction Relief Act. And I'd like to talk a little bit about it because I will introduce a resolution next week calling upon the state legislature to amend and reform this act. I have asked my staff to contact Harrisburg. I will go visit them. The first page of the book that she left me, which is evidence of proof of innocence, is an opinion written by Justice James Fitzgerald, who was specially assigned to Superior Court. And he wrote in concurrence or agreement with the decision that the law was being followed, but this is what he said. He said, "I write separately only to express my utmost displeasure with the Post-Conviction Relief Act's failure to facilitate justice in this case where it is clear to all that it is likely that an innocent man sits behind bars for no better reason than a poorly conceived statute. No system of criminal justice is perfect. However, a system of criminal justice that prevents the correction of obvious errors is easily improved if only the legislature could see fit to do it." This case, in summary, is about a man who is accused of shooting from a terrace another man. A witness, a single witness, said he saw him from a terrace shoot downward and kill the man. At the hearing, there were 3 alibi witnesses sitting in court, but the attorney never called them to testify, and later, many years later after the conviction, it was found that likely the defense attorney never filed notice to the prosecution that they had an alibi witness, and therefore could not present the alibi witness. Since that time, the single eyewitness recanted, saying that he did not tell the truth. But the most critical thing for me is scientific evidence that 2 different weapons were used, a .22 caliber weapon and a .32 caliber weapon, firing horizontally and from down to up. It would be scientifically impossible for the person on the terrace to have shot the bullets that killed this person. He has spent 26 years in jail. Here is the problem with Pennsylvania's Post-Conviction Relief Act. And I did run into this decades ago, and fortunately for the person I represented in a very long process through a writ of habeas corpus in a federal court, the evidence against him was found to be unreliable and he was set free. The problem is that once a person is found guilty in Pennsylvania and the appeals are exhausted, a defendant may file post-conviction relief, and there are limited grounds. Ineffective assistance of counsel is one, newly discovered evidence is the other. However, you have to file within a year, and if you have newly discovered evidence, you have to file within 60 days of the knowledge of that evidence. That may sound simple enough, but in Pennsylvania, the standards are too strict. They're too hard. It's hard to overcome these standards because for ineffective assistance of counsel, it is different than medical malpractice. The standard is that no competent attorney would have done what the attorney did in particularly excluding or not including evidence of innocence. And that evidence has to be of a certain category. And therefore, if an attorney committed malpractice, what I would say is malpractice, that will not provide the defendant an opportunity to have his case heard or the evidence heard. The other issue is that in Pennsylvania, newly discovered evidence is not evidence that you just find. It's evidence that you should have found, could have found, but didn't find. And in Pennsylvania, no matter how poorly represented you are, how illogically you are represented, how terribly you're represented, as long as your lawyer told you what he was going to do, and most people rely on their lawyers, you don't have an appealable basis. I think that the Pennsylvania Post-Conviction Relief Act needs to be amended so that people who have evidence, newly discovered evidence, scientific evidence, recanting of evidence, evidence of attorney malpractice, can appeal and present their evidence, because the way it is right now, it is just nearly impossible in our state. Thank you very much.